And you are Javin Austin Meadows?
This
Is it Javin or Jevin?
Javen.
Javen. Javen, all right, thank you. Defendant is charged with 2 counts of murder, 1 count of attempted murder, 2 counts of felonious assault, strangulation, and a forfeiture. Of the alleged victims or the alleged victims been notified of the hearing and have an opportunity to be present?
They have, Your Honor. 2 of the 3 victims have elected not to attend today. They have all been consulted in this case. They understand. They all agreed to the disposition.
Mr. Meadows is going to plead guilty to counts 1 and 4. Is that correct, Mr. O'Dye?
That's correct.
All right. A charge of murder, an unclassified felony carrying a mandatory sentence of 15 years to life and a fine of $15,000. How do you plead?
Guilty.
Okay. And for the record, the victim in that case was?
William Grooms.
All right, thank you. And as to count 4, which alleges that on or about May 31, 2026 in Highland County, Ohio, you did cause or attempt to cause physical harm to a V2 by means of a deadly weapon or dangerous ordinance, to wit a F-150 truck. How do you plead?
Guilty.
Anything you'd like to present?
Just a few things very quickly, Your Honor. I'm sure the court, obviously from your experience, understands that counts 1 and 2 of the indictment would have merged. They're charged in the alternative. That is part of how we came up with the agreement that we came up with. The other part of how we came up with the agreement that we came up with is simply that victims 2 and 3 in this case, Jada Davis and then the final victim in the case, were extremely understanding and wanted to get this behind them. The reason that we were able to handle this case so quickly, so efficiently, is definitely the work of Detective Butler, who put a huge case together with 3 victims and a lot of moving parts in a very short amount of time, and had all the evidence ready to present to the defense as soon as the case was indicted. So we do appreciate that. There is a family here that is left without their loved one. Miss Grooms is here. The actions of this young man on the day in question left her a widow at a very, very young age. And I know that she would like to address the court.
All right, Mrs. Groom.
Javen, you took the act that I will never forget, that early Sunday morning. You took away my husband, my best friend, my biggest support, all over your actions. Now we have to learn to live without him. My husband didn't deserve this. My husband and son had stayed with girlfriend and ex-girlfriend that night. But you choose to get in that truck and head straight for my husband and hit him. Now we have to call him our hero. You didn't have to do what you did. You could have easily took your truck the opposite way and controlled your actions. It just shows what kind of person you are. Thank you.
And I did read the affidavit from the municipal court. It was my understanding that Mr. Grooms was just a bystander, happened to be there at the time this was taking place. No
Yes.
previous contact between he and the victim that you're aware of.
Well, he was the victim. No contact with the defendant, didn't know who he was at all. There is crystal clear video of this incident, actually. Probably the best video I've seen in 20 plus years. Mr. Grooms and his son Carson are leaving Holtfield. They see what's taking place in the parking lot. They both jump out, leave their doors open, and run over to assist Jada. At that point, the defendant jumps in his truck, makes a very short turn, and just runs over Mr. Grooms and kills him.
There's no words to describe what Jaden did that night. I mean, he wrecked the lives of the Grooms family. And that night, he wrecked his own life, his own family's life, and he caused, if not wrecking Jada Davis's life, he's caused significant turmoil that will take years to heal. But he's a young man. He has never been in any kind of trouble. He's 23 years old. Other than this just one bad evening, he was an exemplary citizen. He worked for the Hague Motors for 4 years. Was a service tech there, making $22 an hour. Now, none of that can really be solace to the groom's family for what he did to you and how he has truly wrecked your family. But this is a young man who I believe he's sincere when he and I would talk. And I've been down to jail a half dozen times to see him. He's a young man who I believe is sincere about rehabilitating himself, never touching alcohol again. I believe alcohol was a real contributing factor in this. His ex had just called off their wedding, and inappropriately, some buddies took him out, and he was drowning his sorrows and using alcohol as a crutch to get through that heartbreak when he did these horrible acts. We would ask the court to go along with this joint recommendation. He's here. He's admitting all of what he did, and he's willing to take responsibility for his actions, even though it's not going to help the groom's family or bring Mr. Grooms back. In light of this tragedy, he has done everything to make it as easy on everybody, to own up to what he did, and I believe he's going to be a model inmate.
I'd like to apologize for my actions. Very selfish. I don't really got much else to say besides I'm sorry. I did not mean to do what I did. I'm owning up to what I did. I can't bring him back, so that's all I have to say.
Anything else?
Yeah, that's all.
Mr. Dye, any other information or?
No, Your Honor.
There's real tragedy here that's being caused by, in my judgment, an act of uncontrollable rage. Alcohol may have been a factor, but I'll say this. I've been around for a long time now, over 50 years in this business, and I see people that are alcoholics and abuse alcohol all the time. Sometimes people say, well, alcohol causes people to do things they wouldn't otherwise do. Others say, and I think maybe there's some truth to that, is that it unmasks who they really are and removes their inhibitions to doing things. In this case, you went into an uncontrollable rage. A lot of people get drunk and just pass out. They become sad. They become jokers. They think lovers. Other people, engage in unspeakable violent acts, and that's what this was. It's a shame that your first offense was such an unspeakable event, and I'm sure that will be present with you, but it'll always be present with the victim's family and friends and the people that he's left behind, and also with your former girlfriend. In fact, that she was also attacked violently, and that's what really caused the event that led to Mr. Grooms' death. So it is the order of the court that you be and are hereby sentenced to a mandatory term of 15 years to life on count 1, and a term of 3 years as a minimum on count 4. Those are to right sexually to one another. You could be kept in prison for life on count 1, but if they do decide to release you, if they determine that post-release control is appropriate, is applicable, I should say, to count 4, then that means that in addition to any parole supervision, you would be supervised for a mandatory period of 5 years. Harm caused in this case was so unusual that no one single prison term for either of the offenses committed as part of the course of conduct would adequately reflect the seriousness of the offender's conduct.
After the preliminary hearing, Judge Randolph ordered that the sheriff's office go take all the firearms out of the defendant's home. They did that. They've been holding them ever since. I put in the entry, if this is okay, that all the firearms being held by the sheriff's office, and there's 10 of them, be released to the defendant's father now.
Okay, that's fine to me. I mean, there's those charge pending. I assume you have no objection.
No objection.
Right. And who is the father? What's the father's name?
Chris Miller.
I'm sorry?
Chris Miller.
All right, go ahead and put that in the entry then.
Thank you.
Yeah. All right, anything further?
No, Your Honor.
All right, thank you. You're remanded custody.
The hearing begins with the court calling the case involving a 46-year-old defendant who had pleaded guilty by way of information to 2 felony counts: domestic violence, a 3rd-degree felony, and menacing by stalking, a 4th-degree felony. Defense counsel explains that the defendant is married, has a GED, and holds a valid driver's license. Counsel asks the judge to consider community control instead of prison. The defense acknowledges a presumption in favor of prison, but argues that prison is not mandatory and that the court has discretion to impose community control. Counsel says the defendant could stay with his godbrother in Richmond Heights and describes his employment at an airplane manufacturing company, where he tested the integrity of jet parts through a heating and treating process. The defendant hopes to return to similar work. Before sentencing, the defendant asks for another chance at life and requests probation, community control, or mental health consideration. He explains that he takes Keppra and lamotrigine for epilepsy and psychiatric purposes. He admits that he made a mistake and handled a family situation incorrectly. He says his son had been rude and disrespectful for a long time, but acknowledges that he handled the situation the wrong way. He asks for a second chance so he can return to work, pay his mortgage and property taxes, follow the court and probation officer, and live normally. He describes himself as a family man who goes to work and comes home, does not associate with criminals, does not run the streets, and can obey the law. He acknowledges prior domestic violence cases, describing them as verbal abuse involving his first wife. He says he is now married to his second wife, owns a home in Lake County, has not been communicating with his family, and has another place where he could live to restart his life and focus on moving forward. The judge questions him about his medical and mental health history. The defendant says he has taken Keppra for about 5 years, and that it was prescribed by a neurologist at a university hospital. He had previously taken Tegretol XR, but it stopped working, so he was switched to another medication that worked much better and prevented seizures. He says he has not had a seizure in more than 3 years. When asked how long he has been receiving mental health medication, he says since approximately 1999 or 2000. The judge points out that the defendant has therefore known about these conditions for nearly 30 years. The judge then examines the defendant's history of domestic violence and assault. He notes 5 prior domestic violence cases, including a felony case from a few years earlier, as well as 2 separate assault cases. The defendant explains that many of the domestic violence cases involved his first wife. He also describes a later case in which he allegedly assaulted paramedics and a police officer after having a seizure. He says he blacked out and did not know what happened, was hospitalized at University Hospital, and remained in a coma for approximately 3 or 4 days. When he woke, he did not know what year it was and stayed in the hospital while recovering. He says he was later told that he had assaulted the paramedics and police officer. The judge asks about the present cases involving the defendant's son and wife. The defendant says his son had been unruly and disrespectful for about 6 months. He claims he repeatedly gave his son chances, talked to him, and tried not to put his hands on him. He says the disrespect toward him and his wife contributed to a mental health breakdown. Regarding his wife, he says she became involved because she was trying to stop the conflict between him and his son. When the judge asks whether he is blaming his son, the defendant says he is not putting all the blame on his son and admits that he himself is at fault as well. The judge asks what physical contact resulted in the present case. The defendant says he and his son were wrestling. He pushed his son away and kicked him in the nose. He then describes a separate box cutter incident. He says he took a box cutter from his son because he feared the son might cut him, and his wife pulled it from his hand, cutting her index finger. The defendant says his son was angry, upset, and afraid of him, and that he had threatened the son because of what he considered disrespectful behavior. The incident occurred shortly after Christmas. The judge also asks about property and money the defendant had given his son. The defendant says he allowed his son to use a Lexus for about a year and gave him $4,000 to hold around tax season. The judge finds this explanation difficult to believe. He asks why the defendant would give money and a vehicle to his son he describes as such a serious problem. The defendant says his son was good at holding money and that his wife tended to spend money. He says he allowed his son to use the Lexus because his wife used a Toyota and he did not want the son walking to school while the adults went to work. The judge says that if his own child behaved like the defendant describes, he would remove privileges such as a car rather than continue providing them. The judge then states directly that he does not believe the defendant's account and believes the defendant is trying to sell the court a softened version of events. The judge points to the defendant's prior domestic violence record and rejects the characterization that the earlier cases were merely verbal arguments. The judge then questions the box cutter incident and whether it involved marijuana. The defendant denies drug involvement in that incident and says he does not use drugs. The judge immediately challenges that claim by reviewing the defendant's drug convictions. The defendant acknowledges a cocaine trafficking conviction from around 2000 and says he was about 20 years old at the time. He confirms that he went to prison and was released in 2001 after approximately 5 or 6 months. The judge then identifies additional convictions: marijuana in 2002, drug abuse in 2003, another drug abuse case in 2009, felony drug possession in 2014, and another drug abuse case in 2017. The judge says this history conflicts with the defendant's attempt to portray drugs as something from the distant past. The judge observes that the defendant has dealt with mental health problems and medication since approximately 1999, while also having repeated drug offenses and a violent history. The defendant admits he has a violent history. The judge says he believes the defendant is minimizing what happened. The defendant denies this and insists he is telling the truth. He returns to his explanation that he was angry because his son was going to school late and was supposed to learn welding. He says he did not want his son to be late and describes his earlier convictions as mistakes from when he was young. The defendant's wife then addresses the court. She says she has been with him for approximately 20 years and married to him for 13. She explains that she repeatedly tried to get him to change his medication. She says he had been placed on Keppra after pancreatitis and that he was already somewhat abusive, but she believed the medication made his behavior significantly worse. She says she and their son begged him to see another doctor and eventually got him to visit another university doctor. His medication was changed, but he stopped taking the new medication because it caused constipation and did not return for further treatment. She also explains that the defendant gave the Lexus to their son and that the son had been paying him $600 per month, keeping a written record of each payment. She says she loved the defendant, wants him to receive the mental health treatment he needs, and recognizes that he has serious problems. The defendant's son then testifies. He says his father's account contains lies and that he can no longer trust him. He explains that his father gave him a car and that they had an agreement concerning payments, but the father stopped paying after losing his job at the airplane-related company in 2022. The son says the abuse had been occurring since he was a child and that he witnessed his mother being beaten by his father. He also describes a box cutter incident, saying his father had the box cutter during an argument and that the situation became physical. The son says he attempted to break up the conflict and was assaulted by his father. The prosecutor explains that the case involves 2 victims, the son for count 1 and the wife for count 2. The state says count 1 involved an extended period of conduct, including the box cutter incident and the kick to the son's nose. The prosecutor also identifies an earlier incident in January 2025 in which the defendant allegedly punched his son in the mouth and split his lip, and a November 2025 incident in which he allegedly placed his hands around the son's neck and left marks. The kick and box cutter incident occurred in December 2025. The prosecutor says the violence was accompanied by repeated threats and that the state received more than a dozen recordings dating back to December 2024 involving statements about shooting, killing, hurting, and threatening the son, wife, or both. The prosecutor also discusses statements in which the defendant allegedly threatened to die or provoke police to kill him. The state says he told probation that if he could not be with his wife and son, he would kill himself. The prosecutor emphasizes that these statements were concerning and had a serious emotional effect on both victims. The state argues that the conduct caused not only physical injuries, but also significant mental and emotional harm, especially because the son had